Chris, Ashley, I get this a lot. Children, what age can the child decide which parent to go with? I know it's changed over the years, but I get that question a lot to ask the guest that's coming on.
Exactly, and that is a very common question. A judge will quite often listen to a child and take a child's wishes into account when the child's between the ages of 11 and 14. But at the age of 14, a child can pretty much decide which parent they would prefer to live with, and a judge will, it's called an election, an affidavit of election. And the judge will comply with that child's election so long as the other parent cannot show that the parent the child's electing to live with is unfit. Then the judge will comply with that child's wishes.
Okay.
And speaking of that, Ashley, tell us a little bit about the different types of custody. We hear, joint custody, legal custody, sole custody. Well, what's all the custody? Yeah, what's that all about?
It's very confusing, yes. Well, you have two different, and I explain to my clients, this two completely separate almost like two sports, basketball and baseball, totally separate when you're dealing with legal custody, which has to be determined, and physical custody. Physical custody is what amount of time that child is with each parent. And so if the child is primarily with one parent, such as like during the school week, and has visitation with the other parent every other weekend, then you would have one parent being the primary physical custodian and the other parent having visitation rights. If the child were to swap back and forth like on a week-to-week basis, then you would have a joint physical custody arrangement. But another determination that has to be determined either by a judge or by an agreement that's entered into the court would be legal custody. And that's determining who has the right to make decisions that affect this child's long-term well-being, such as medical, extracurricular education, and religious upbringing. And so a court will determine a tiebreaker parent if the parents are unable to agree, which parent can make the tiebreaker decision for important decisions in those areas.
So you could actually have true joint physical and legal custody.
Yes, you can.
But then there's a tiebreaker that the judge will determine.
Right.
Okay.
Does that usually addressed in the divorce action, or is that usually back when you have a conflict, there can't be a decision made and both parties go back before a judge?
Well, in the divorce action, a tiebreaker parent will always be determined.
Okay.
And so that will be included in the final.
Opinions expressed on Law Call are those of the participants and do not necessarily reflect the opinions of 13 WMAZ staff or management, nor any legal or judicial entity. The legal information supplied in this broadcast is general information only and is not intended to be legal advice for any given situation. Do not rely on broadcast information without consulting an attorney. Contingent attorney's fees refers only to those fees charged by the attorneys for legal services. Such fees are not permitted in all types of cases. Court costs and other additional expenses of legal action usually must be paid by the client.